Meaning of a limited liability company, LLC. A limited liability company, LLC, is a business structure that legally separates the owners, called shareholders or members, from the business entity. This means that the personal assets of the owners are protected in case the business incurs debts or faces lawsuits. The liability of each member is limited to the amount they have invested in the business. An LLC combines features of both a corporation and a partnership, offering operational flexibility and limited liability protection. It is registered under corporate laws of the country or state in which it operates. In Nigeria, for example, LLCs are registered under the Companies and Allied Matters Act, CAMA, and regulated by the Corporate Affairs Commission, CAC.
Key features of a limited liability company. 1. Separate legal entity. An LLC is treated as a distinct legal personality. It can own property, enter into contracts, sue and be sued in its own name. This separateness gives it continuity beyond the involvement of its founders. 2. Limited liability. The most attractive feature. Shareholders or members are not personally responsible for the debts or obligations of the company beyond the capital they invested. Their personal assets remain protected. 3. Perpetual succession. The life of the company is not affected by the death, bankruptcy, or resignation of a shareholder. The company continues to exist until it is formally dissolved. 4. Minimum and maximum membership. In most countries, an LLC can be formed by a minimum of one person and may have up to 50 or more shareholders, depending on the jurisdiction. In Nigeria, a private limited company requires 1 hingga 50 shareholders, while a public limited company may exceed that.
Types of limited liability companies. 1. Private Limited Liability Company, LTD. This type of company does not offer its shares to the public. It is typically owned by a small group of individuals, such as a family or group of investors. Examples: family-owned businesses, SMEs, and startups. Key features: maximum 50 shareholders, restricted transfer of shares, not required to publish financial reports publicly. 2. Public Limited Liability Company, PLC. A company that sells its shares to the public via a stock exchange. It requires higher capital, greater transparency, and stricter regulation. Key features: unlimited number of shareholders, shares freely transferable. Subject to strict disclosure, reporting, and audit requirements, must publish accounts and hold AGMS3. Single Member Company, SMC. This is a private company owned by only one person. While the structure and function remain similar to other LLCs, the key difference is that it has only one shareholder, who may also be the sole director. Popular among freelancers, solo entrepreneurs, consultants.
Advantages of a limited liability company. 1. Personal asset protection. The key benefit. Members are not personally liable for the company's debts. Creditors can't go after the personal assets of members. 2. Perpetual existence. Oaks continue to exist regardless of changes in ownership. This ensures business continuity, enhances credibility, and facilitates long-term contracts. 3. Enhanced credibility. Being a registered LLC builds trust with banks, investors, and clients. It signals professionalism and commitment to legal standards. 4. Ownership flexibility. Members can be individuals, other companies, foreign investors, or combinations. This flexibility allows for diversified ownership. 5. Attracts investment. Compared to sole proprietorships or partnerships, OCs are more attractive to investors, venture capitalists, and banks due to their structure, governance, and scalability.
Limitations of a limited liability company. 1. Regulatory compliance and complexity. LLCs face more paperwork, regulatory filings, and inspections. They must comply with rules from CAC, FIRS, and other bodies. 2. Cost of formation and operation. Compared to a sole proprietorship, forming and maintaining an LLC involves higher registration fees, legal services, and annual filing costs. 3. Limited control in public companies. Founders may lose decision-making control as shares are sold to the public. Shareholder activism can affect company policy. 4. Public disclosure obligations. Public companies are legally required to publish their financial statements, affecting their privacy and competitive edge. 5. Profit sharing. In large LLCs, especially public ones, profits must be shared among many shareholders, reducing returns for original founders. 6th. Slower decision-making.
Bureaucracy in larger companies may lead to slow responses, delays in decision-making, and complex management structures.